in the month of March, and
I was one among them.
and then they got infected. Actually, some of
luckily, I'm staying safe. So let's see what happens.
I think we are live, huh?
Okay. Hello and welcome. Good evening, good afternoon, good morning to all of you who have tuned in today from different parts of the globe to watch this panel discussion on NLU Delhi's YouTube channel. I hope you're all doing well and staying safe as the deadly second wave of COVID-19 pandemic has hit India. The news of people losing their lives to the pandemic at an unprecedented scale has in India has struck chord with the entire world. Our hearts go out to friends and families who have lost their near and dear ones to the pandemic across the globe. As a nation and the world attempts to get a grip on how to deal with the current situation and defeat the pandemic with all its might, an impending question on the role of intellectual property in the context of innovation and access to COVID-19 vaccines and drugs have raised some sort of existential questions, I must say. We in India have been witnessing shortages where names of drugs which you have never heard of, like remdesivir, have now become part of common knowledge. As the pandemic ravages through various parts of the country and also in some other parts of the world, the issue of how to make vaccines available to the entire world at the quickest possible time is at the center of how we can overcome the pandemic. Surely IP is not the only issue in the context of vaccines and drug production, and we should be mindful of the same. Vaccine production has heavy quality control requirements and scaling facilities may take time. There are also questions of incentives for producers who wish to scale up, irrespective of what we think on the IP questions. We are still lucky that innovation by private and also through public-private initiatives during the early stages of the pandemic have borne fruits, as vaccines are already being rolled out or are in the process of being rolled out in different parts of the world. Clearly, vaccine equity matters, and how we achieve it quickly remains a concern. It is in the spirit that India and South Africa, joined by almost 2/3 now of the WTO members, have been vociferously demanding suspension of IP rights contained in the TRIPS agreement since October 2020, as far as COVID-19 technologies are concerned. Others argue that flexibilities in the TRIPS agreement, read along with the 2001 Doha Declaration on TRIPS and Public Health, provides ample regulatory autonomy to deal with the pandemic. As disagreement on the waiver proposal persists, there are hectic parleys going on in Geneva right now and elsewhere on how to get countries together, particularly when India has agreed to submit a revised text proposal. However, it remains to be seen how suspending intellectual property protection will help countries to quickly access complex technologies that are in the form of know-how and trade secrets, which are in the exclusive possession of vaccine technologies. Be it as it may, even before the waiver has taken effect, Brazil from across the Atlantic is in news recently for its extraordinary move of suspending COVID-19 patents if patent holders fail to deliver know-how and trade secrets to produce technology as part of compulsory licenses, and also with a fixed royalty of 1.5% on the licensed technology. Whether it would lead to massive scaling up remains to be seen. Back home in India, the Supreme Court has just recently sounded an alarm indicating that the government of India should evoke its emergency powers and consider them under India's patent laws. Just today, we have heard news of NATCO licensing application on baricitinib, that is with the brand name Olumiant, for which a patent in India is held by Insight Holdings Corporation with a license from Eli Lilly. So there are many still unanswered questions, and it is in this background the IPR chair at National Law University Delhi, sponsored by the Department of Industrial Policy and Promotion, that is now the Department for Promotion of Industry and International Trade, Ministry of Commerce and Industry, is pleased to hold this panel discussion today. With us, we have a panel of eminent experts who have extensively worked on IP and health issues. I'm pleased to welcome Madam Jayashree Vatal, who is now an honorary professor at the National Law University Delhi and is also a former senior counselor of the IP, Government Procurement and Competition Division of the WTO. We all know Madam Jayashree's work through her insightful books and other articles which she has extensively published. We have with us Mr. K.M. Gopkumar, who is a senior researcher and legal advisor at the Third World Network. His advocacy around health issues is globally recognized, and we are very glad and fortunate to have him with us today. Mr. Murli Lilkantan is with us to bring in legal perspectives on IP and the interface of health law. Murli is India's prominent legal expert on health laws. And Prashant Reddy, of course, is a familiar name in the academic IP circles because of his insightful pieces on spicy IP and other forums, including his recent book on India's IP Dilemma published by OUP. We are indeed honored to have NLUD Vice Chancellor Professor Rao, who has taken great leadership in encouraging the faculty and students to raise the bar towards achieving higher levels of academic consciousness. He has kindly agreed to deliver the inaugural remarks. So before we proceed towards the inaugural remarks by Professor Rao, some housekeeping announcements. We'll have 5 rounds of questions, roughly between 12 to 15 minutes each. And towards the end, we'll take the question and answers. You can type in your questions in the YouTube chat box that you have, and we'll be happy to answer them. Of course, we'll not be able to take all the questions, but we'll try and answer most of the questions that we think are very pressing and relevant. So with this, I would now request Professor Vice Chancellor Rao to deliver the inaugural remarks. Professor Rao, over to you.
Very good evening, everyone. I'm delighted to welcome you all to this panel discussion organized by the IPR chair at National Law University, Delhi. We are grateful to the experts who have kindly agreed to join in today and the audience who are watching this live from all over the world. It's a grim occasion to discuss the issues of intellectual property and the pandemic in the midst of a grave situation where India is facing a deadly second wave of COVID-19. Our hearts pour out to people and families who have lost their near and dear ones. I appreciate and commend my colleagues in NLU Delhi for taking this initiative to organize this panel discussion on a variety of cross-cutting issues involving intellectual property law and the pandemic. Let me share 3 ideas and concerns. First and foremost is innovation and access to vaccines. We are all aware that the intellectual property laws are based on the idea of creating incentives for individuals and firms that assume disproportionate risk in the process of innovation. Most vaccines and drugs for COVID-19 that are currently approved are invented by firms who assumed such risk based on the legal protection afforded by the IP laws. We are also equally concerned about the social cost of monopoly when the rules of the market take time and money to make the vaccines accessible to the lost persons. This issue remains critical that leads to a sharp divide between innovation and access. Second important issue is about barriers to the access to vaccines. This is the dilemma. There is a lot of access to vaccines versus barriers to vaccines. Access to vaccines and drugs for COVID-19 is a top priority for countries like India, as until everyone is safe, no one is safe. But there are several barriers for access to vaccines that leads to delay in preventing harm and benefiting public at large, particularly in the Indian and third world context. We have several barriers: scientific barriers, legal barriers in the name of intellectual property law, regulatory barriers such as WTO regime, and logistical barriers, so on and so forth. Ultimately, the poor and the common man is denied and delayed access to vaccine. The third and the larger issue is, Yogesh already pointed out, is a vaccine equity. The time has come to take action and how to make a fair and equitable distribution of vaccines as soon as possible. How to achieve vaccine equity remains a challenge globally and not just in India. However, it's an immediate challenge for lower, middle income and least developed countries where the scale of populations affected by the pandemic, livelihood issues, and economic recoveries are very different. It is in this spirit Yogesh has pointed out about India and South Africa, joined by other countries from the African group, and the least developed countries made a proposal for waiver of IP rights at the WTO. While it remains to be seen how this proposal will ensure technology transfer when IP rules are suspended domestically. As we have seen, the Supreme Court of India, Delhi High Court has taken a lead. That's what the people have expected. They have risen to the occasion. And Supreme Court of India in its recent order observed that the government should not hesitate to take measures under IP laws to enhance the production of vaccines and drugs that are immediate use for the COVID-19. In this time of crisis, it is our moral and humanitarian duty to find workable solutions to save lives, heal India and the world from this ravaging pandemic. Maybe Narayana Murthy sometime back has said compassionate capitalism, or the recent debate of constitutional morality I will extend to corporate morality. And I think we need to find workable solutions to save lives, heal India, and prevent from this unprecedented pandemic. It's time for corporation to show the compassionate gesture in the rising pandemic. I'm sure this panel discussion will attempt to answer the most difficult and challenging questions of our times. I once again welcome and thank you all on behalf of my own self and the National Law University Delhi for this panel discussion. Thank you.
Thank you, Professor Rao, for your inaugural remarks. Thank you indeed. With this, we will, Professor Rao has already set the tone of the discussion, and we'll directly move on to the hot button issues that we promised that we will discuss and raise them. And we are here to raise some tough questions. We'll have those questions answered by our eminent experts. So one of the first issues, I think, is the question of facts. As lawyers, sometimes we ask for more facts and more evidence-based questions. So I would straight away go to Prashant and ask him, what is the entire IP and technology landscape of COVID-19 vaccines and drugs that we are currently seeing in India and elsewhere? Over to you, Prashant.
Thank you, Yogesh. Thanks for having me. And this is a bit of a surreal event. This is the first time I think I'm having an IP conference in the backdrop of a pandemic, where a lot of us know people who have suffered immensely because of it. So let me just get down to the broad question that you asked me on what exactly is the technological and IP landscape, primarily for vaccines. As you know, right now there are about 8 vaccines which have been approved globally. 5 of these are in the Western world, and then there's 1 Russian, 1 Chinese, and 1 Indian vaccine. Of the 5 Western vaccines, 3 have been licensed to India. That is AstraZeneca, Novavax, J&J, have all licensed their vaccines to be manufactured in India. And this happened very, very long ago. So AstraZeneca licensed its vaccine on 4th June of last year for about production of 1 billion doses. Novavax, which is another American company, entered into a licensing agreement again with Serum Institute on 15 September for 1.1 billion doses. J&J entered into a deal with Biological E on 13th August last year for 600 million doses, and this is a single-shot vaccine. And I think this is being ramped up now with American funding through the Quad for up to 1 billion doses. So all these 3 American vaccines have already been licensed to Indian manufacturers. The only American vaccines that have not yet been licensed are Pfizer's and Moderna's RNA vaccines. The other 2 vaccines that have been licensed in India, one is the Russian vaccine Sputnik. It's not clear how many Indian companies they've licensed it to. The last count I had was about 6 Indian companies, including Dr. Reddy's, Hetero, Virchow, Gland Pharma, Panacea. And I think the Russians are aiming to make India their production hub with about manufacturing about 850 million doses. And then there is Bharat Biotech, which has produced Covaxin along with support from the Indian government, especially ICMR and NIV, that's the National Institute of Virology. And they are promising that they can scale up their production to about 700 million doses. And they've entered into a deal with Indian Immunologicals Limited. That's again a PSU, where they're going to transfer some technology towards manufacture. So if you look at the doses that are being manufactured by all these companies, it looks on paper at least like they have enough capacity to deal with the demand in India and then some, right? Because from what I can calculate, it's almost, it'll almost touch somewhere around 400 billion doses. The big problem appears to be scaling up manufacture. As you know, vaccines aren't easy to reverse engineer or manufacture, especially some vaccines like Covaxin, which is an inactivated virus vaccine, the oldest kind, oldest technology, oldest vaccine technology. That technology, those vaccines apparently can be manufactured only in BSL-3 facilities, and there appears to be a shortage of those in India. The remaining vaccines are all recombinant vaccines. That is, there's some amount of genetic engineering that is happening. You certainly need certain capacity. And it looks like these companies have given out licenses to India. The only other vaccine, if you don't have, is the Chinese vaccine, because nobody's asking for it in India. On the drug side, Remdesivir, Gilead had already given out 7 voluntary licenses to 7 different companies. And I believe there are 20 plants which are manufacturing these in India. Steroids, which is perhaps the only effective therapy for one of the side effects of COVID, which is the cytokine storm. Dexamethasone and the other steroids are anyway not patented, yet they are in short supply in India because there seems to be some distribution issues or people are hoarding it. And the third drug, which is there in the national guidelines, is tocilizumab, which is, again, it's a biologic manufactured by Roche, sold by Cipla in India. This is again, this drug is in shortage. It's prescribed in the national treatment guidelines as a fallback if steroids don't work that well. And tocilizumab is again, because it's a biologic, it's very difficult to reverse engineer and manufacture. So you'll have to send it through clinical trials. It can be done. I think Hetero has just announced that it's going to start manufacturing it, although it's not clear whether it's applying for a compulsory license or not. So if you look at most of these drugs, my assessment would be that IP is not really the issue, because a lot of this technology is already transferred license to Indian companies. I think the crucial question is scaling up manufacture, and that's a different can of worms, which I hope is open during the course of the discussion. Sorry, I think a minute more.
Thank you, Prashant. And we'll quickly move to other panelists and have their quick reaction on other kinds of issues in relation to the same question of the technological and innovation landscape. So, Madam Vatal, I'll start with you. Can you explain what could have gone into innovating these vaccines in terms of global cooperation, public-private partnerships, etc.? Because we have seen that most of these vaccines have come out from different countries, but particularly Western countries. And what kind of impetus was provided for making of these vaccines? Because that's where the context of assuming risk and risk-taking comes into picture. So, ma'am. Your microphone, ma'am. Your microphone.
Thanks, Yogesh, and thanks to you and Professor Rao for inviting me onto this panel. So I am not, I haven't done the kind of research that that Prashant did to kind of lay out all this, in detail. Very useful. All I can say is what was the motivation of all the 200 or anyway hundreds of efforts that were made to come out with the vaccine as soon as the genome sequence was put out by China early 2020, very early. Everyone was racing into this because by then it was clear this was extremely infectious, contagious. Therefore, there was likely to be a huge global market. So what was motivating everyone, all the private sector companies that were rushing in to do this research was really money, right? Let's be clear about that. It was profits that was motivating everyone. And the fact that in most of the places where such efforts were being made, intellectual property would also be safeguarded. That was taken for granted. However, the pace at which the developments took place and the results finally came out would not have been the same without the governments putting in the money. So you have the United States and the European Union in particular that had put in money into this. Now for the mRNA technologies, already, even before COVID, there was money being put in by the National Institutes of Health, is my understanding. This is all hearsay. I'm not a first-hand expert on anything. But just to say that the pace, in my view, the acceleration that took place was because a lot of money came in from outside of the companies to the promising candidates. Obviously, everyone didn't get it. And some of the promising candidates, by the way, who got the money have not yet actually delivered on the vaccine. So this was not a surety that governments putting in the money would result in, they made the best bets. Meanwhile, India, in collaboration with AstraZeneca, Serum Institute also put in money in terms of expanding facilities, in terms of gearing up for the production of the AstraZeneca vaccine. Again, taking a risk, because by that time, the regulatory approvals had not been given, and it was not very clear this would be the success that it was, it has been, to the extent that it has been eventually. Bharat Biotech, equally motivated by getting in a vaccine that works for India and for the rest of the world. And ICMR, and as you said in your initial remarks, Yogesh, they put in the money, or was it Prashant? Prashant also said ICMR and the Virology Institute in Pune, they also got together, and it was a joint effort which came out with indigenous vaccine, which of course Indians are very proud of, to have their own successful vaccine in the market. So all I want to say is that all these factors were important. The fact that there was going to be a large market, the volumes were going to be promising and very, very large. This is why there was this so-called vaccine rush, like the gold rush. Everyone wanted to get a piece of the pie. And then you had the government also stepping up to do this. Private companies, again, making investments in advance, taking the risk of doing that, not knowing whether they would be a success. Some of them have not yet come into the market, as I said. So, and intellectual property. So, as Professor Rao said, many pieces of the puzzle, intellectual property is one of them, and certainly not unimportant. So, this is where I'd like to stop. Yeah.
Thank you, Jayshree ma'am. Gopal, one of the questions that has been raised in the context of these vaccines is the public-private nature of partnerships, because most of these vaccines, except Pfizer, if I can recollect from my memory, have been. Even Pfizer is. Murli is saying, I think even Pfizer
is UPenn, University of Pennsylvania.
Okay. At least newspapers have not clarified, but most of them received some kind of funding, publicly funded taxpayers' money from different countries. So in that light, how do you see the dilemmas of innovation, where incentives are not just required for initially coming out with an early stage lab kind of inventions, but also to commercialize them, take them to the market, because you have to conduct clinical trials and put them out in the market. And there you have intellectual property acting not just as incentives for innovation, but also incentives for commercialization. And how do you look at these dynamics in terms of the entire technological landscape and the IP landscape? Gopal, your microphone.
Let me just directly answer this question. Like, one of the important justifications for intellectual property right or patent protection is always the recouping of the R&D cost, and without exclusivity, nobody is ready to put the money there. But if you look at the pre-COVID days, vaccine is always a case of market failure, because vaccine is by and large is a procurement market. And that is being created by the state intervention. It is not the private market. And it's also very, very, a few firms control in terms of volume. Like vaccine production in India, China, they share actually 52% of the global market. But if you look at the volume, value, it's just, five countries share the substantial value of the pharmaceutical, the global vaccine market, and it is driven by and large through the procurement market. So companies are in a way reluctant to invest in vaccine. One theory is that, okay, you are many of the classical sense, the vaccine actually prevent the infection, and that's end of the disease, eradication. So your business model is gone. Once you develop a vaccine, you make money and then it's gone. So, but you keep a treatment possibility, there is a chance of, your business keep going. So, but let us keep that apart. But I am saying that in the pre-COVID days itself, with all the innovation, innovation stimulus, in the sense like coming from the mainstream intellectual property protection, there was a market failure for vaccine, because the SARS vaccine, there was move to develop a, in the early 2005, when there was SARS outbreak, to develop a vaccine. Then after that MERS outbreak, there was an effort to make a vaccine, but all those things did not succeed. But here, the COVID outbreak is a case in point where huge public investment came in, and there was complete de-risking of innovation as well as production. Companies receive money either for innovation or to expand their manufacturing capacities and through advanced market commitments. So there was complete de-risking happened. And it shows that without intellectual property protection, actually you can extract innovation, or you can pull products, health products into the market. And one of the surveys, one of the institute looked at the volume of money which went into the R&D, and they found that around 93 billion public fund has been spent either for advanced market commitments or for innovation. And out of that, 95% went to vaccine. So there is a heavy funding on vaccines. And that takes me to my last point. And we were told that recouping is the important justification for patent protections. Here, it's completely public money, but still companies are not ready to give up their monopoly. So
yeah, but this also
then you are innovating and another justification for to having a monopoly. Okay, so it is not for the monopoly rights like patent is not to protect the innovation, but it's rather you are now innovating a new justification to keep the monopoly. So that's where we are.
But this also begs into the question of what are the terms and conditions under which the federal governments funded, several governments funded them to private entities. Now, if there was no allurement of the patents or no allurement of keeping their IP, how many of them would have really taken the risk? Now, let's speak to Murli and find out whether you would have many others in the Indian biotech scenario where Bharat Biotech actually took the risk of collaborating with ICMR and NIV, and then doing some part of clinical trials, and others was done by the publicly funded money. So in such a situation, risk assumption by these players, when there are multiple, why do we have only few that run to the government and take that money and do it? Is it that all companies in India actually were interested in collaborating with the ICMR and NIV? Or why is it that only Bharat Biotech did it? And I think there is a question of risk. Murli, if you could clear on that particular issue, because you have been vociferous on the question of who owns IP on Covaxin, Bharat's Covaxin.
I'll come to Covaxin last, but I think Professor Rao raised the issue of risk. Gopa has addressed it briefly. But if you look at the risk here, the patents, if you go back and trace, the patent for Pfizer was filed in the name of two scientists from the University of Pennsylvania. So whenever somebody says Pfizer has patents on this, and there is some fantastic know-how that they created rapidly in the 3 months, I think they have to all calm down and go and see the patent portfolio behind the Pfizer vaccine. So it starts off with UPenn, and there is a licensing from UPenn of the mRNA technology through a process, a holding company, and then eventually to Pfizer. So that's your, if you want to go back to patents for innovation, then clearly Pfizer didn't innovate anything there with the patents. Similarly with with the AstraZeneca vaccine, where Oxford actually has licensed and developed with AstraZeneca. So it is not as if these people, spent $1 billion suddenly between February and June and had this fantastic product. I mean, I'd love to see Pfizer, Moderna, AstraZeneca all show me $1 billion spent in 2 months in development of this vaccine. It just is not true. So let's start from there. So there is no risk that they have taken in this, in monetary risk in this. Similarly with Novavax. So that risk goes. You spoke about the great risk that Serum Institute took. Absolutely no risk. The money they spent, they raised about 800 million last year. I'd like to see what they spent it on. There is no clarity that they spent 800 million, which they raised last year, in the 6 months of last year. And to put it in context, the AstraZeneca license was signed in June 2020. The first batch, production batch, was produced in October 2020. If you take 120 days to cook the vaccine, which is the process it takes to make the vaccine, you go back to which day? Therefore, the tech transfer took how long? Few weeks. So where is this great investment at risk that Serum Institute took? There was no risk there. They already had an advance purchase agreement with AstraZeneca. So AstraZeneca may have taken the risk of the clinical trial for a period of time. That's really the only risk. And they anyway had advance purchase agreements. So again, there was no real financial risk there. So I think we should stop talking about risk that billions of dollars have been risked by these powerful corporations for vaccines. So nobody has shown us where these billions of dollars were spent. There are no billions of dollars that were spent. On the issue of tech transfer, I said it's going to take a couple of weeks. So everybody talking about it's going to take several months to do a tech transfer. Please look at the chronology that I've just given you. Agreement signed in June, tech transfer completed in July, validation batches produced, production batch, the first production batch that is sold in India, I have the label for it, was 29th of October 2020. So in just a few months. So there was no great tech transfer. So it's very easy to do tech transfer. I have also the agreement for Brazil, where a similar provision, and we have a similar timeline there. On the issue of we don't have BSL-3 facilities in India, we have over a dozen BSL-3 facilities in India, including with, so it's not a real issue. And to upgrade existing facilities to BSL-2 is a 2-month job. So we can manufacture. I think there are a lot of these myths that have been put out there to say, oh my God, there is IP. Oh my God, there's tech transfer. There is some secret sauce. We just can't reverse engineer it. Perhaps we can't. Given the time, it doesn't make sense to reverse engineer it. But these are the facts that we need to discuss. And all the discussions we have on the law and restrictions and all of that have to be seen in these contexts. So using the word risk, using the word innovation in the private market, and lack of production facilities for scale are really not facts.
Well, there is one question though, in terms of co-assumption of risk by Serum Institute, for example. So if AstraZeneca's trial, at level 3 failed, then where would be the vaccine out, and what would Serum Institute do with all this, money that they were trying to put? So that question still remains. Yes, Gopa, you want to?
It doesn't. Let me answer it. I'll let Gopa answer as well. But let me just answer that. Serum didn't put any money. You keep saying Serum put money. Where is the money? Gates gave them 200 million. There was an advance purchase agreement from Serum for everything that they were going to produce. Where is that money? Working capital is not investment. So let's not keep saying this. There is no evidence that they spent 800 million of their own money to build this plant or do anything of the sort. It was somebody else's money. And we in India are very good with other people's money.
Gopa, you wanted to quickly jump in?
Yeah, I think it's actually $300 million. That's what the Gates gave as a grant, okay, just to expand the production capacity. So here, look, this
that was for COVAX, right? I mean, it's not just
it is not routed through COVAX. Okay, it is directly given by
Gates
by Gates. Okay, because of various other formalities, they just went through the Gates route. and it is Gates money, and it is given just as grant. And that time when the questions were put on to the Gates Foundation, what happens if the vaccine fails? Then they told that, okay, that can be used for some other vaccine production. That was the arrangement. Okay, so it was more or less an unconditional transfer of money. That's the first thing. And the second thing, we should also look at the fact that what is the actual real investment required to expand the production. So you are, these technologies are existing technologies. It's not like an mRNA plant. Okay, these are existing technologies. Vaccines are produced using those technologies. So your major investment is basically your bioreactor capacity. You need to expand your bioreactor capacity, and how much it is required. Actually, for every 100 million doses, something like a 30 crore rupees or something, right? So that's what people say. So you add a billion doses, even if it's 30 crores each, 300 crores, okay? But you got a $300 million, okay? So this is the volume we are talking about. And
but it is interesting that we didn't ask this question ex ante when all these things were not even clear during the same period last year.
You don't have to ask until and unless things goes wrong, right? So
okay. Prashant, you want to quickly react?
Yeah, see, first of all, I'm not sure why we're discussing Serum Institute of India. I mean, they are not the patent owners over here. They've just taken something, their pricing dispute with the government and how much they're charging their legitimate concerns, which I think perhaps we could have another panel on that, on drug pricing. But a lot of these calculations that we're making, we're now making it in hindsight because we know that all these vaccines finally did get through. When in June to August, when a lot of these deals were being signed, we didn't know how many of these vaccines would actually get through. And Merck, which is one of the biggest vaccine manufacturers, their candidate failed. Sanofi, their candidate failed. So there was a risk, and there was a huge opportunity cost to that effect. Now again, I don't know. I don't think we need to be discussing Serum over here. If the focus is IP. The focus should be on.
I had particularly asked Murli on the covaxin question, the covaxin IP question, just to get some clarity on.
There are again legitimate questions on who owns what. We still don't know. There's a lot of confusion out there.
We do know. We now have a statement from ICMR. From Balram Bhargava to say that there is shared ownership. He used the word shared ownership. Now, we don't know what that is. We haven't seen a memorandum of understanding. They say that they have a memorandum of understanding. At this time last year, just about this time last year, they announced it. They had said that they would fund the clinical trials. If you go to the Clinical Trial Register of India, it shows ICMR as a co-sponsor. In fact, at that time, we raised issues of conflict of interest. Here is a co-sponsor who is also supervising and regulating clinical trials and looking at clinical trials. So there were conflict of issues then, but to say now that we don't know what the ownership is, we do. We have no numbers from either ICMR. I mean, I hope when they announce when we see their results, once audited by CAG or thereabouts, we will see what their expenditure on this is, but we get to see it. Bharat Biotech has not said anywhere that it has spent, 700 crores or 1,000 crores or anything of the sort.
I think there is a 350 crore figure that is floating, and I think Mr. Ella has come on record.
I think the ICMR today. I think it is reported in Hindu or something. ICMR actually claimed that royalty for license.
Yeah.
That shows that there is a complete ownership, at least a 50-50 ownership. Otherwise, you won't.
No, I mean the agreement would still be different.
It's a public good, and in a country like India is asking for a waiver on the other side.
Yeah, so that brings me to the next question immediately. If it's considered as a public good now, in hindsight, we can now treat it as a public good because there is a necessity. What's the actual, access scenario in terms of COVID vaccines, COVID-19 vaccines in India? Because, there is deep vaccine inequity between West and the East. They have some countries like Israel has 52%, Seychelles has 59%, 30% in, of course, countries with some smaller population, you will always have higher rates of, full inoculation. But nevertheless, even the US has around 30%, and we are, stuck around, less than 2%. So in such a scenario, what is the actual, kind of vaccine inequities that you see? Gopa, can you just take this question head on and, try and address this?
I know there is no numbers per se, but people say 70 to 80% population-wide coverage is required to have some kind of effectiveness of the vaccine to feel in the country. So in India, that is around 70% of the population. So that means around 95 crores should be vaccinated. That's around roughly putting it around 190 crores doses. So as of now, the vaccine coverage is just 2% or slightly more than 2% of the population. I mean, those who had 2 doses of vaccine. So we have miles to go and miles to go. And this should be done at a greater speed. Okay, if you do it in the 5 years, there is no effectiveness of the vaccine. So you have to do it in the great speed at the maximum minimum possible time. That is the challenge here. That means you have to scale up the production. So what's the capacity? Production capacity. Serum says that okay, their monthly output is around 75 million. They may increase it by 100 million. Then Bharat Biotech output is somewhere around 5 million now, or they also in one statement said that okay, end of 2021 they will produce around 711 million. That means 7 crores. Okay, so 100 crores means 100 million means 10 crore. Okay, so this is a very it takes around 1.5 years or something to have a vaccine coverage. And also keep in mind that Serum Institute has obligations to supply to COVAX, and also they have obligations to supply whenever AstraZeneca. That's what people suspect. Nobody has seen the agreement, but we have seen they are exporting to certain countries, which orders actually came to AstraZeneca. So they do have this kind of contractual obligation. So that basically means you have to scale up the production. You have to diversify the manufacturing base. So that's very important. So as Prashant earlier pointed out, there are 6 to 7 companies. I had it 7 and Prashant counted around 6. So 6 to 7 companies obtained the license for manufacturing Sputnik. And they need around 3 months to start the production. Okay? But that is taking a regulatory question right now. And there is no sign of we are resolving that issue. So it may take time. So from a policy perspective, government should diversify the manufacturing base and in order to scale up the manufacturing. Then apart from our own market, you cannot have vaccine nationalism. And traditionally, and India's India's own projection as a pharmacy of the world. Now it's a time you have to fulfill that also. There are many countries who are depending upon India. So you have to supply there too. So there is a huge demand, and you are left with the 2 companies. So we need to move away from this duopoly. We have to completely diversify the manufacturing base. That can bring down even the price. The price may come down if you allow another 5 to 8 companies to come into the market. If the 10 companies are producing, then the vaccine price will come down below 100. And maybe it may stabilize it even at 1 dose around 10 rupees or something. It can happen, but you should allow more manufacturers to come in. But currently, that's not happening.
Yeah, but Prashant, you mentioned that there were so many deals signed already, right? At least 5 vaccines are already in India. With several different Indian players, Indian vaccine producers. Now, if you put them totally together, their annual commitments, would we be able to achieve this equity question quickly? In the sense that, at least in terms of numbers, we know that we are having enough vaccines, at least whenever they are rolled out during this course of time, during the year or so.
Yeah. So. I don't know, I think my rough calculations came to around 4 billion doses, but that's across a year. So right now, I think by end of December, God knows how many we can actually vaccinate. I doubt it will be even half the country. But
right now, I think it's 500 million. It's 500 million right now. Currently, what is being produced, rolled out already. So
yeah, no, a lot of them haven't even started rolling out. Like biologically, J&J, I don't think they're starting till August. A lot of these, the Russian licensees, God knows where they're going to start. Novavax, there's a supply crunch of input ingredients or whatever Poonawalla has been claiming. So even that's, I think it was supposed to launch in June or something. So again, over here, the problem is, it's not IP, right? It is the government of India did not place the orders at the right time. And that is a fact that we really need to drive through, because it looks like the media, the mainstream media is too afraid to raise this point vocally. Somebody messed up really badly by not placing orders earlier. And I think a part of it has got to do with how the Indian bureaucracy works, because placing orders for a vaccine which you don't know is actually going to clear clinical trials can lead to a scandal in India. I mean, today in hindsight, we're all saying that, you know, this is nonsense. They should have placed orders, but the bureaucracy thinks very differently, and that's the scandal. Like even in January, February, why didn't we place mass orders? That is the problem. The problem was not IP. The tech and everything was transferred. We've got our procurement policy wrong. Murli's written a great piece, a couple of great pieces on how bad the procurement policy has been planned out by the government of India. And as for COVAX, you know, I agree with Gopal. Like, this is the time that we should be living up to our reputation of the developing world's pharmacy. But what has happened, in effect, the government of India has a de facto ban on exports. Yeah. If you look at the Ministry of External Affairs site, where they have listed, vaccine exports, April 21st is the last recording that they have. And even by then, the graph of supply was really, petering down. So there are some major issues that we need to ask of the government, which are not related to IP in my opinion.
So could I just say one thing? I have done some math on the projections for the year on capacities. And my arithmetic shows that we will have 141 crore doses by the end of the year, assuming Serum goes to its full capacity, which is 9 crore a month. Bharat Biotech goes from what it is really 1.2 crores to 5 crores a month. Sputnik goes to peak capacity of 5.2 crores a month. And we get 1.8 crores from the COVAX facility, which we are entitled to. So if you add all of this up and assuming everything goes right, we'll get 141 crores. This is the capacity that everybody's announced, which is still not enough to get us very far. So that's our first problem. The second problem I think nobody's talking about is India placed all its bets on Novavax, not on AstraZeneca. So India made commitments to Novavax rather than to the AstraZeneca vaccine. And Novavax is a very interesting history, which is that the last 2 attempts that they've had at producing a vaccine hasn't worked. The flu vaccine for Tamiflu didn't work. And Tamiflu became the response to that. But the important thing to note there is we did place, the last time we had a flu pandemic and we thought it would be great, the government of India actually procured from Novavax and placed orders on Novavax and got H1N1 flu vac, despite it not having much use because swine flu just went away. So we have had situations in the past where government has procured in that sense at risk and had to just throw it away because there's really not much use for it, or find a way of repurposing it, which is send it back to exports to countries which have swine flu. So we have history of governments acting in anticipation of a pandemic, doing it in the past. I think nobody's writing enough about the Novavax India story, which is that India just bet on the wrong horse. And I use that word horse quite advisedly.
Okay, thanks. Thank you, Murli. But one of the questions still remains, with vaccines, the kind of strains that we are seeing, we may need new vaccines also in the process, and maybe some permanent solution to tackle all the kind of strains that are going to come. So there is a kind of different kind of equity question in terms of how much can states also do in terms of getting vaccines rolled out for different mutants and strains. So that brings me to the third question. Now, if there is a situation of the entire innovation and tech landscape and the access situation when you have glaring inequities, But is IP a barrier in scaling up production when technology licenses are available? Because as we see, at least in case of India, we have already 5 licenses available. So, Madam Vatal, I would like to start with you. How do you see IP, the question of IP as a barrier in the context of scaling up production when licenses are available?
Thanks, Yogesh. But if you give me a minute, I would like to react to some of the points that were made earlier. So Murli made some interesting calculations and said 1410. I say everything in million because, the international audience prefers something that they can understand. So if you have 410 million doses by the end of 2021, that's your calculation, according to what people have announced, then in my view, and this is something that Gopa said, that if we are to inoculate 70% of the Indian population to achieve some kind of herd immunity, then that means 950 million. Am I right?
No. Sorry, could I just correct that? It's 1.4 billion, not 410 million. 141 crores is 1.4 billion.
It's the same. 1410 million, I said. Yeah, it's the same.
No, so, it's not 40. Okay.
1410 million is 1.4
billion. Yeah, got it.
So I'm just converting all these figures to million just so that the international audience understands also. So you have 1410 million doses to be supplied by Indian companies or manufactured in India by end of 2021, this year. And Gopa said that 950 million people need to be inoculated. And if you take that and multiply that, it would be 1900 million doses. So we are pretty close to, I'm saying production and supply is not the same thing. Production and, jab in the arm is not the same thing. But by early 2022, looks like we will be quite close to inoculating at least the adult population of India, those 18 and above, by early 22, right? If not because the production by the end of 21 and then you project it to early 22, you should be able to achieve herd immunity, if all goes right, by early 2022, okay, which is much faster, I think, than many countries in the world. But here we are assuming that everything that we produce in India will be used in India and not kind of sent anywhere else. So of course we don't know what the contracts are and what will go out, but we won't obviously be able to keep the entire thing in India. So anyway, this is a better projection than I had assumed earlier. So I think we're not so badly off as many other countries are in this. Then I would also like to correct this view Murli gave, that, Big Pharma really took no risk at all. Nobody took any risk. It was all, money given by outsiders, and therefore there was no. Now, come on, that is a very absolute statement. And I don't think, we should say things like no risk, absolutely. I mean, it's very nice to say it because it's very forceful and it kind of gets the message across. But I think it's too absolute a statement, because you do have the development aspects. And like Yogesh said, when all these things were done and the contracts were being signed, no one really had a clue whether these things would go through phase 3. How many cases we know of failures in phase 3? And, even now, even after the rollout, there are adverse side effects, except that they are so rare that most countries have said AstraZeneca and J&J, which have the blood clotting issue, they should go ahead. Nevertheless, I'm just saying that there are risks involved. To say that there was no risk at all is not correct at all, in my view, no matter who did the research. Because doing the initial research is one thing, but subsequently taking it to the point of manufacture and regulatory approval is quite another thing. So in my view, the development risks were taken. They were taken with the promise of intellectual property, as was already there. There was no talk at that time that intellectual property is not going to be there. So assuming that it was going to be there, these companies did take the risk. They brought the vaccines in record time. And I'm saying, in my view, and this is just top of my head, I mean, there's no empirical evidence to what I say, but I'm just saying the acceleration that took place, the speed at which it came about was perhaps helped because of the money given by governments. Now, clearly, one of the companies, Moderna, for whatever reasons they had, they said that their patents on the mRNA vaccine are not going to be enforced. Okay. At that time, civil society organizations I saw in the press did welcome this as a step and encouraged others to do the same. No one else has done it. It's right. However, I don't see any third parties producing the mRNA vaccines either, right? And I know a lot of companies in India would love to have the Pfizer and the Moderna vaccines, as in many other LMICs, they would love to have licenses for the mRNA vaccines. Now, and these are, of course, not only because of the efficacy, because they are easy to adjust to variants, they are quick to produce, and there are so many reasons why this technology should be more widespread, which is why the WHO has focused on mRNA and put out some kind of call for expertise in this area. Just like to say, it's very interesting, for me to have read very recently the story of how India acquired penicillin in the past, when no private company in the world was giving penicillin technology to India after its independence. The first Prime Minister of India then was persuaded to go through WHO and UNICEF, the two together, to acquire the penicillin technology. How did WHO have it? Because at that time, penicillin, of course, was not patented, but there were a lot of there were a lot of patents afterwards. And so it was not easy. There was threat of patent litigation even then when India tried to get it, through the WHO and UNICEF. But it turns out that the patents were examined, India took the risk, and it was one of the big issues why India changed its law in 1970 to abolish patents also, because of the penicillin story. What I'm saying is, we don't have right now any international organization which has the capacity or has the ability and the confidence to tell LMICs, that is competent companies and LMICs, qualified companies and LMICs, to tell them, listen, we can help you with this transfer of technology. We can actually, that is how India got it. So there is no such thing. WHO is trying now to try and get this, but we don't know if that will be a success or not. So in such a situation, I think, given that vaccines are a global public good, capacity by itself is not a problem, but getting the best vaccines, the most appropriate vaccines is an important issue. We need to think in that context. Would it just be enough? Because I do believe it's important to get those technologies. So would it just be enough to say no patents on this, or no, just TRIPS does not apply? If TRIPS does not apply, why doesn't Bangladesh, which has very good vaccine manufacturing facilities, why don't they start doing mRNA vaccines? It's not that easy. You need the cooperation of the right holder, which means for the time being, till WHO finds another solution, we need to actually find a way of getting the companies to cooperate. What is the incentives that these companies need to immediately, without any, without any hesitation, without any further delay, to say, yes, we can give it to competent, that is qualified companies. So,
Prashant, sorry, go ahead.
Yeah, go ahead. Let me, I can go on forever. So let's Prashant talk.
So
I just has his hand up.
Gopa has his hand up? I think
Prashant, start then.
Yeah. Prashant, the question, for example, on the IP as a barrier in India has been misconstrued, and we have been having our offline chats, of the record chats, wherein we have been trying to point out the remdesivir question and other questions on intellectual property, particularly, when you have so many licensees already producing it, where is there a need for a compulsory license, because IP is somehow acting as a barrier? And also in case of other biological drugs, whether IP poses a barrier, or there are other kinds of structural tech barriers and regulatory barriers that one would encounter. Even on the recent question of NATCO's compulsory license application, looking at the Indian jurisprudence on injunctions, we would be actually surprised to see why NATCO didn't take the risk of going directly to the market, because they already have a regulatory clearance, from what I understand. So, no court in not just in India, across the world, would grant an injunction, on something that is closely remotely related to COVID, because it's a benevolence, but because the law says that balance of convenience and public interest must be accounted for in granting of injunctions, right? So, in such a situation, do we really think that the question of tech access is a barrier and posed by intellectual property regime? Or are there, distinct royalty-related issues in terms of, how much royalties, these people would end up paying, either from by way of a compulsory license, or even if an injunction is not granted, because ultimately it would be an ongoing royalty that would be paid to the patent holders.
I mean, actually, if you look at the law, a lot of these vaccines, I'm sure, have not yet been patented. There are just filed patent applications. You have to wait 3-4 years before you get that patent. And under Indian law, under Section 11A, you cannot be sued for patent infringement, anybody for patent infringement, until you're actually granted a patent. Although your rights and privileges start running from the date on which the patent application is published. So that's basically, it operates then like a retrospective compulsory license, in the sense that your damages clock starts running from the day you infringe the patent, but they cannot sue you, the patentee cannot sue you for an injunction until he is granted a patent, and which we all know will not happen for 3 or 4 years. So, I mean, the NATCO case is slightly different because that drug is patented. But for a lot of the other vaccines, technically, if they want to, patents are definitely not a barrier in India. They can go ahead and do that, unless they're intermediary technologies which are patented. That's a different question. But to come back to the core of your question, I don't think IP is a big issue here. In the sense that a lot of this technology will require some amount of transfer of know-how from the patentee. This is not the case for small molecule drugs, but it is the case for vaccines and biologics. Now, it's not a question of how much time it's going to take. I mean, it may just take 2 months or 3 months, but you need to give an incentive for this company to transfer its know-how to the other company. You can do it the coercive way, like how the Brazilians are doing it, putting a gun to the patentee's head and saying that you're going to lose your patents, etc. It'll be great to see how this plays out. I'm glad we have a real life example in Brazil to see how this plays out in real life, whether it actually incentivizes companies to move ahead, or is it going to destabilize trade between, the Americans, Europeans, and the Brazilians. So I think this know-how question is somehow it's getting missed in this debate, because a lot of this, I think the activism that is informing this present TRIPS waiver is informed by the 1999 South Africa crisis, which was very different. I mean, you had a Yusuf Hamid there who was ready to slug it out, and he had the capacity to reverse engineer those drugs easily. With these vaccines, we know it is difficult to reverse engineer. Even presuming they reverse engineer, it will have to go through a new set of clinical trials, because it's essentially going to be a new product. And that's where we don't have the time, I think, for a clinical trial. Although, I mean, I would say that I think India, given its present surge, we should be able to conduct a clinical trial in like 3 weeks, perhaps, even a phase 3 clinical trial, given the number of cases that are going on. So I don't think, I think we're wasting, not this panel, but generally we're wasting a lot of time on discussing IP when we know that there are non-IP barriers, including, problems with inputs from the US. These guys want easy capital, which the government gave them only recently, and plus know-how, technology transfers, and even BSL-3 facilities. I know Murli says that it's 2 months, but the Haftine Institute director is on record in a newspaper article saying it takes 12 months. If a government guy says it takes 12 months to manufacture a safe vaccine, I would give him 18 months to do it. Because I've just seen Chernobyl, and authoritarian regimes and public sector enterprises, you have to be very careful with safety. But that's my take. I'm sure nobody.
So, Prashant, I'll just answer that question. It's because the Hafkin Institute facility is very, very old. It is not easy to expand. It's not. It's in the middle of town. Okay, it's in Parel. So to be able to do anything sensible there, which is and the difference is just how you handle air. How do you keep things safe? You have an environment which is completely sanitized. All of that. So it's not as if they don't know how to make vaccines. It is a very old facility in terms of its infrastructure. So for them to be able to upgrade it in the middle of town during this time is going to be really hard. Whereas many of the others already have, 20 acres, 30 acres of space. You can easily put up a facility. You don't have any restrictions of movement. And a lot of them already manufacture quite difficult vaccines to make. So they're dealing with technology which is kind of familiar to them. They can do the tech transfer quicker. So there are slightly different issues with saying Hafkin will take a year. And the reason they're saying a year is actually they're going to take 4 or 5 months only to create a plant. Then they will start the tech transfer. Then they will do a validation batch. Then they will do a production batch. So because the timeline to cook this damn thing is going to be at least 4 months, to get your first validation batch is 4 months. To get your first production batch after that is the next 4 months. So 8 months is just going to be this. And you need a little time to build the facility. So that's how you get to them saying it could take us up to a year to produce a good batch. So that's how the calendar works as far as their timeline goes. I said it could be quicker because a lot of the other facilities are already ahead. And so they could get this tech transfer done much quicker. We're talking weeks. And this is Covaxin being licensed to Hafkin. Slightly different from the AstraZeneca product or the Zydus product or the Sputnik product, which is much easier to manage and handle. So slightly different technologies, slightly different facilities.
Gopa, would you like to answer the question on Remdesivir, compulsory license? Because many public activists have been demanding that Remdesivir must be compulsory licensed, and tocilizumab and others must be compulsory licensed also. So what actually is the Remdesivir controversy on compulsory licenses? Because it is already licensed on zero royalties to 7 companies which operate 20 plants, which have a capacity of 1.3 crore. That is, Madam Vatal, what would be 1.3 crores? around 10 million doses. 10 million. Yeah, 10 million doses. And in that situation, is IP the real barrier?
I'll answer Remdesivir as well as on the vaccine also. I would like to respond on this first on Remdesivir. So you look at the government's notification. They have allocated around 1 crore doses or something already.
So 10 million doses.
Yeah, one person need around 6 vials. Okay, so that will be roughly around how much it is for the patients, around 12 million patients. 1.2 million patients, right? So you have a number of around 3 lakhs plus or 300,000 plus patients every day. And Remdesivir, by the way, in India, it is for the patients who are admitted in hospital. But really, it is actually useful when you give it at the earliest, actually. It is not, complications started and then you give it. It will not have the optimal effect. Okay? And second, what's the price? The lowest price, which, they all came and together and they agreed, voluntarily cut is 899 rupees per dose. Actually, the study shows that the Liverpool study shows that all the 6 doses you require only cost manufacturing cost plus a 35% profit. You can give it around $9. Okay. So that means the conventional economic sense tells you that, okay, these 7 companies, they are now acting like a cartel, right? So you need more companies to come in, more doses should be produced. So doses may come around May 15. I think that's what, they companies, because there was no demand, till month of, till maybe Feb. So,
but just to intervene, yeah. The price that you're quoting does not include any IP royalties, right? Because the IP royalty is 0.
Yeah, Yeah, whatever, yeah. But the problem is that 7 companies are producing it, okay, and they are charging, they are taking people for a ride, and even black market and everything is happening. And
those are other
collector, have you heard that district collector is allocating a medicine in the, you are talking about, you are proud of a free market. In 1991, everything changed in India, right? License Raj, permit Raj, everything is gone. But now the district collector is allocating the medicine. So this is, so this is the situation. So more companies need to come, and this technology is there, and it can be easily produced, and the price can come down. So that is the need of the hour. Therefore, the Supreme Court has directed, and even if you need an ultimate green signal, that is the USTR, they also gave. So in the USTR Special 301, they basically said that, okay, you should use, they respect the right of trading partners to use the compulsory license. So you got all the signals. So now the time to act. So having said this, let me come to this vaccine question. So, vaccine, so every time the pharmaceutical companies uses IP and regulatory framework to check the competition. And the regulatory framework is, we don't touch them. We look it as a very sacrosanct because it is safety and efficacy. But that is not that innocent. I'll show you an example also. So here, as Prashant put it out, you need, if you are not getting the technology, and especially the cell lines, except mRNA, all other vaccine technologies, you need a cell line. So if you do not get that from the originator, you have a burden of proving safety and efficacy and manufacturing process. Okay. So actually, this is a trade secret. This is IP. Why this manufacturing process is not in the public domain? Why the cell line is not in a cell bank to be deposited? If you need a patent under the Budapest Treaty, a microorganism should be deposited. But in the case of, if you do not have you do not want a patent, you can, you don't have to deposit anything. Okay, so this is kept as a trade secret, and the regulatory agencies acting like an enforcement agency for the trade secrets of the vaccine companies and the biotherapeutics companies. Okay?
I would leave that regulatory question to Prashant also, but before that, I quickly want to interject and ask you one thing, Gopa.
Yeah.
If the demand for remdesivir is so much that any private company would want to enter the market, who is stopping them to launch it? Because as I mentioned, no country, particularly India, will grant an injunction. So compulsory license is actually redundant in that sense.
These are guesswork. Okay, Delhi High Court, how many injunctions they have granted, even
not in a situation where you have
you cannot, the lawyers, end of the day, you cannot speculate on these things, right? Law is there, and we don't know how the court is going to act. Okay, so therefore, but there is a legal way. There is, the government should act this moment. That's what the Supreme Court give all the right nudges for them. Okay, let us wait what's going to happen, and whether the Supreme Court also, whether they give only nudges or whether they really act and they order. You cannot request all the time to the government, right? If they are not acting, court has to act now, because it's a suo motu petition too. Okay, so every constitutional authorities have to rise to the occasion and act upon it. Okay, so I feel that there would be something will be coming out. Okay.
Yeah. Ready?
No, see, on remdesivir, I think it'll be first interesting to see if anybody even files for a compulsory license. I'm not sure why that's not being done.
Because it's, you cannot file under Section 84 also, Prashant, because some of these patents are actually 2019, and after 3 years, Section 84 doesn't apply actually. But,
yes, sir. But if you look at the compulsory license filed by NATCO today, I think Guruswamy Nataraj is their lawyer. He's tried to use an innovative strategy, saying that
but they also has been declared. They also approached the Supreme Court for a 92 declaration and order. Okay?
Yeah. So they are now
just
trying
for the
to
background of our viewers. Under India's patent law, Section 92 states that the government, that is the appropriate government, can issue a notification in cases of national emergency, circumstance of extreme urgency, and public non-commercial use, wherein a third party need not go and ask the patent holder, try and negotiate, and then apply for a compulsory license, which is actually a market-driven process. But this is more like a government notifying, and then any person can apply with the controller for a compulsory license. And now I think the discussion can go on. Yes, please.
Yeah, so it will be interesting to see if anybody files it. I think what's happened fundamentally over the last 15 years is that apart from the early years in the pharma industry where Cipla was ready to lock horns at the drop of a hat, it has now moved to taking licenses from big pharma companies, whether from Roche. I mean, whoever thought Roche and Cipla would be in bed together? And then there's Gilead. They've been taking licenses from a lot of companies. The only company that I see which is out to fight right now is Natco. So I think the signal has gone out to the pharma industry that, why don't you just sign up for licenses with us? We'll be out of price control. We can cartelize the prices much better under a patent licensing agreement. And there's no incentive to really take on big pharma. It'll be interesting to see for how long Natco can hold out on this trend. On the regulatory issue, yes, I mean, Indian, first of all, there are concerns with a couple of these vaccines, which I don't think we are paying enough attention to. And even public health activists in India, I see, tend to focus more on the access question, that is getting drugs at a cheap price. But the safety question is left out because both with Bharat Biotech and the Russian vaccine, serious red flags have been raised, and we don't know what CDSCO is doing. Now, on the question of regulatory issues, posing a barrier to competition, I think that's inevitable in the sense that if certain technologies do need to go through certain kinds of validation processes. If it's a new cell line, then you have to do a new phase 3 study. I mean, if the ideas that Gopa is suggesting, you keep a sample of the cell line with the regulator, which can then be used for compulsory licensing later, and perhaps in the future, but even then, the cell line is only one part of the entire vaccine manufacturing process, right? You have these lipid nanoparticles, and all this goes over my head. That's why I became a lawyer. But this stuff is going to be difficult to reverse engineer, I think, even if you do have a cell line. Thus, Bharat Biotech's vaccine will be slightly easier. But yes, regulatory, and I can understand where this suspicion is coming from, because if you look at the US, the American history in the 60s and 70s, there's been a huge tussle between generics and originator companies, where the regulatory law became the site of tussle over competition. And Big Pharma does have a pretty unsavory history when it comes to painting, generics as substandard, et cetera, et cetera. Now, there are certain concerns, especially in countries like India, when it comes to quality control. But yes, I think regulatory law will always be like this.
Yeah, thanks, Prashant. And let's quickly move on to the next question on waiver. So if there are flexibilities in the TRIPS agreement, provide, on issues of limited exceptions, compulsory licenses, government use, non-commercial use, national emergency situations, including, injunctions are not mandated under TRIPS. Damages, are left to the judiciary. Injunctions are also left to the judiciary to, as long as the judiciary has the powers to grant them. So with all these flexibilities, including, the fact that we have a moratorium on non-violation complaints, India and South Africa made a proposal for the waiver, suggesting that or indicating that these flexibilities are not enough, including the Doha Declaration on TRIPS in public health. So what really went on, into making this proposal? Because there is a view that perhaps we don't need the waiver because there are flexibilities. The other view is that, even if we have the waiver, how are we going to induce technology transfer? Because suspending trade secrets, for example, because patents more or less are now a legal barrier. But trade secrets and know-how is most structural impediment for vaccine production, right? And if that be the case, how is it that suspending somebody's trade secret, pulls the firm into, or makes the firm, transfer the technology unless there is some, kind of draconian criminal measure that is applied against these companies? And that's been my question as to how the waiver is going to help. So I would start with, Gopa first, and then, allow Jayashree to respond.
Yeah, it is basically emanating from this, again, the regulatory barrier. When we say about the regulatory barrier, we are not saying that the regulatory barrier should undermine the safety and efficacy concerns. But what we are saying is that there is a development in the science and technology that can be used to address these concerns.
I think we can keep those questions, regulatory questions.
Just that.
But let's move on to the IP quickly.
From there, I am moving to the IP. Okay. So if you take all these vaccine technologies for COVID, okay, except mRNA, all are biologics. mRNA is typically a chemical vaccine. Okay. So eventually, maybe 5 years down the line, 6 years down the line, an mRNA vaccine could be approved like a generic medicine without a clinical trial. Even in the current, so what I'm saying is that now mRNA vaccine and biologic vaccines are regulated through the same process. Okay, many of your concerns on the regulatory concerns which is coming from is actually because of it's a biologics. Okay, so that's that may happen. Okay, and second, if you look at, I'll just take one example where the tocilizumab, okay, which has a patent, but if it is approved for the compulsory license, it will be very difficult to produce under the current guideline because you need a comparative clinical trial. And the comparative clinical trial is a WHO regulation which we adopted. Our regulatory framework was slightly different, but there is no scientific base for to have a comparative clinical trial. Now the WHO in April put a draft guideline for comments, and which says that you can do away with the comparative clinical trial. That means your development time is going to be really, really short.
In case of biologics?
Yeah, biosimilars, not biotherapeutics originators, but a biosimilar version. Okay, so you will you can do away with the comparative clinical trials. Why this happened? This happened because of the developments in the analytical technologies. Because all the questions start from how do you characterize the molecule? Because that is like a trade secret, right? Normally kept as a trade secret. There was no mechanism to get it from regulatory agencies or anything. So the characterization, the analytical technologies improved so much, you can characterize the originator molecule more or less same. So therefore, the regulatory burden is coming down. So similarly, on many vaccines, say flu vaccine, all the flu vaccines, every year there is a new version, it's a new variant. It is treated as without phase 3 trial. Right.
So, Gopa, on the waiver question, can you quickly
so I'm
come
coming
to
to the waiver question. So quickly on how waiver will applicable in the case of trade secret. So in the trade secret, all other products are concerned, trade secret is not a big issue. And the trade secret is an issue when coming to the vaccines. So here there is a regulatory dossiers. Okay, you don't have to force you have to twist the hand of the originator. Okay, you have the regulatory dossier. This regulatory dossier can be used on two ways. One is it can be shared with the potential manufacturer, and secondly, you can rely on the originator's dossiers and develop markers, develop what you call immunogenicity correlates, and then you can do away with the phase 3 trial, or you can have a very truncated trial, okay, to approve a non-originator vaccine. So these possibilities are there. Article 39.3, let me come.
Yes.
It is treated as a trade secret, but there is an exception to protect public. To protect public, you have to. You can do away with the secrecy, right?
Then that comes to a question: why a waiver if TRIPS already allows it?
Let me complete. Okay, but who is going to determine protecting the public means this, or who is going to say the word say that you can disclose the information by taking measures without an unfair commercial? It should not lead to unfair commercial use. Who is going to interpret? End of the day, it's appellate body, right? Appellate body does not function for the moment, but end of the day, there is a legal uncertainty there. There is a need of an interpretation, right? And that will be ultimately decided in a litigation. So therefore, that creates a chilling effect. So here you want to have absolute clarity. So that's where the utility of a waiver proposal. And secondly, we should also look at it in realistic terms. Look, till recently, every time the developing countries try to use compulsory license or any other flexibilities, they were asked, they all came under pressure from countries like US. There was heavy bilateral pressure. So you don't want to use, even in India, one of the reports you say that the Indian officials made a commitment, that is in the submission of one of the industry association in 2016, that they will not issue a compulsory license. Now US is still, the USTR report now say that, okay, encourage trading partners to use compulsory license, but still India is put on priority watch list for using the flexibilities again, and 3D is one of the reasons they have cited. So historically, there is a chilling effect when it comes to use of flexibility. So because of all.
Yeah, I will ask.
It's a global solution, so you have much more clarity. So that's why, like what happened in 2001, right? That moment, okay. But then that what happened to the Doha Declaration.
Yeah. So just to intervene, Gopa, we are running short of time, so I'll quickly have Madam Jayashree's reaction to it as to what is it that the waiver would do if that the flexibilities that does not provide currently. So that's the question.
So thanks, Yogesh, and thanks, Gopa. I think Gopa has been very nuanced in what he said. And I think more or less, Gopa has also said there is only a question of legal uncertainty. Now, you can say there is some nuanced legal uncertainty here, and therefore we need this. And you're willing to go from October 2020 to probably December 2021, even if it moves to text-based negotiations, to get some solution on this. So clearly, it's not the central issue, because obviously we need a solution much faster, and it's not necessary to get everything absolutely crystal clear before you take any action. It's in a situation like this, which is an unprecedented, global health problem, a pandemic like this. So I don't think Gopa has said anything, which I need to respond to. What I fail to understand is that there are people in civil society and in those who have proposed the waiver who understand all this very well. Why have they made it the central issue? My fear is that if the US, for example, decides, let us give on this issue, but don't do anything else, that would have been your biggest ask, which the US would have conceded, and you would not be better off by even one vaccine. And that is the fear, that, you have 175, former heads of state and Nobel Prize laureates. You have lots of, extremely credible people backing the waiver. And with all this pressure, including members of the European Parliament and whatever, every day you hear more and more people backing the waiver, influential opinion makers. And everyone says, yeah, let's do it. Let's start text-based negotiations. You have nothing left to ask. You've asked, that was your biggest ask, it was conceded, and you get nothing out of it. So I think that's the big danger of the IP waiver proposal.
There is an impending question on the on exports. If not made under waiver, then 31 bis is going to be difficult in terms of export licenses, and that's the reason we need a waiver. How far is that true? Because from my knowledge, even if you break patents or even trade secrets, where in case of trade secret violations, courts have not granted injunctions, including in the United States, and those products are freely moving across the globe. Take your smartphones. So in case of smartphones, if not granting the injunctions and ongoing royalties held in global trade or in relation to IP products, why would it not help in case of vaccines and other products? Still remains a question. And that's the reason, if Prashant wants to add something on the waiver issue, and then we'll quickly move on to the concluding part.
Yeah, I don't think the waiver is really about increasing supply of vaccines. It's a golden opportunity to bash TRIPS. And I mean, the public health activists, to their credit, have managed to build, I think, quite a solid support base for this idea. Because if you can drive home this point that TRIPS can be waived even for 2 years, you're going to be relooking the entire basis of TRIPS, which was very controversial when India signed it in the first place. So I look at it as more of as an activist movement to try and rewrite the rules of international trade and IP. So because you're now the legitimacy, I think this is the biggest crisis of legitimacy faced by TRIPS since 1994. I mean, we thought South Africa was bad, but this is 10 times worse. The AIDS crisis in South Africa in 1999, but this is 10 times worse. And I think a lot of people in the general public are convinced that they are not getting a vaccine because of something called intellectual property rights. And you have to give credit, I think, to the people who have thought up of this strategy. because it has definitely worked to a large extent in delegitimizing, IP and leading more people to question what are these greedy pharmaceutical companies doing. I don't think it has anything to do with actually increasing supply of vaccines.
Yeah. Thanks, Prashant. And then we'll quickly move on to the last set of round as to what are India's options now. Now, if the waiver is going to take time, compulsory licenses are going to operate, but then you have also issues with tech transfer. How is it, that we are going to, scale up production? What are India's options? I would like to start with Murli, because Murli, you have been quite vocal in terms of using, 26B of the drugs, and Cosmetics Act, and you have also, said that we should use other kinds of laws to, force production. So how do you envisage the situation of forced production?
So that was a good line last year, Yogesh, when we had spare capacity. So last year, when I wrote the piece, we hadn't have all these deals signed up yet. So we had a lot of spare capacity. These were vaccines which were still in development, hadn't cleared clinical trials. So we had capacity in India, which we could have used to produce other vaccines. So, for example, Zydus has capacity built up, but doesn't have a vaccine yet. Panacea can make vaccines, has capacity, but hasn't produced one yet. Hasn't produced Covaxin yet, and is likely not to produce Sputnik until a few months later. So at that time, I had said that we have spare capacity, and under 26B, a direction can be issued by simple notification for these facilities to produce Covaxin. So there were no IP issues involved there at all. A simple direction from the central government could have got effectively a lease of these plants for Bharat Biotech or for Covishield by Serum. So that was what I had suggested as a non-IP solution to increase production. We've done something similar in the past. We've directed certain industries to produce certain goods during emergencies. We do it regularly for agricultural products where we stop exports to control price, or we import to control price. So we have, both under the Essential Commodities Act and under the Drugs Act, the ability to direct what products should be produced, how much of it should be produced. So to me, that was a non-IP, non-regulatory solution that was available to the Indian government last year. To do it now may be a little too late, because everybody has already started producing these products. So it was an idea for the time. It may still work, because we still have Covaxin, which can be used in several other facilities which are not producing any of the COVID vaccines. So we have capacity that is not producing COVID vaccines. So to that extent, 26B is still available.
Gopal, what are your suggestions towards solutions to scale up production?
One big capacity we have not used is the government also has a vaccine park near Chennai. It's setting up, so not a single dose has come out from there. So this can be leased out actually. So having said this, I think government should have a look at all these details of these contractual agreements, what is actually written there. Say Serum Institute Novavax agreement. Actually, Novavax prevented Serum from producing the vaccine material, but there is a correction carried out till recently, it seems. So now it is allowed. So we don't know government or we don't know what exactly the written in those contracts. So these contracts needs to be looked into. And then if there are anti-competitive provisions and other things, I think government should take measures to enhance the production. So similarly, we say there are 7 companies who got the license. I also thought that it's a full license to produce, and of course it's a full license to produce. Technology transfer is there, but the issue is that it is also in a way indirectly a contractual agreement, because there is a commitment to supply to the Russian direct investment fund, actually RDIF. So though there might be an understanding that because India is a huge market, 50% might be selling here, but these companies have commitment to supply to RDIF. Okay, so we don't know exactly, though these volume we are projecting, looking at the various statements from these companies, etc. But we don't know the details. So therefore, Government of India should look at it. Second, Government of India should widely license at least COVAX, which is, according to them, they do have a claim. And here there is a, trade secret and IP issues, not the patent, but the trade secret issues can be easily, and regulatory issues can be easily bypassed, because cell line is there and the technology can be transferred. So within 3 months, the production can start. Actually, the products can come out in the market. So you can fast track the production. So these are the things government should do immediately. But when it comes to medicines, I think the remdesivir and other medicines, they should look at it and issue a license. So what prevents them from doing that? Tocilizumab, the government order says that some states got 100 vials. Government of Kerala got 50 vials or something, right?
But, yeah, those are distribution kind of issues. But in terms of IP options,
there is no local production of that tocilizumab in India. Okay, it is marketed under a license. Again, you need to carry out the regulatory reform and fast track the approval of tocilizumab, especially in the light of the WHO's new draft guideline. So they have circulated this guideline. It is yet to be adopted, but that's a clear indication. You can have a biosimilar without a phase 3 trial. So
yeah, Prashant, quickly on India's options.
Yeah, see, on India's options, I think, the Essential Commodities Act, definitely the government has draconian powers. It's because the Essential Commodities Act is a rewrite of the Defense of India Act from the 40s. I don't agree with Murli that Section 26B can be used, the Drugs and Cosmetics Act. I read the Drugs and Cosmetics Act as being limited to just approvals and bans, quality control issues. But what the government should be doing now is be a bit more transparent, lay out its cards on the table, let us know what exactly are the orders on, that they have placed, what is the delivery timelines, and give us a proper assessment of what are the other vaccine facilities that can be used to manufacture this vaccine. Because at the end of the day, you need to remember there are certain vaccines for the immunization program which will have to be manufactured every year, whether it's polio or DPT. So certain capacity obviously has to be reserved for that. If there is excess capacity like that plant in Tamil Nadu, the brand new plant was built and is not doing anything, the government does need to utilize this extra capacity to, manufacture whatever vaccines possible. And if required, it should even lean on big pharma companies a little bit and tell them, why don't you license even to so-and-so companies and give them a good deal on how that manufacture can happen. The problem is we aren't seeing this government do anything on vaccines. And unless Poonawalla opens his mouth and makes an outrageous statement, we don't hear anything from the government of India. Our only hope is Poonawalla keeps giving interviews and the government and he keep coming up with clarifications the next day.
Jayshree ma'am, would you like to just place your bets on India's options?
I'll take off from the point that Prashant made, that government should lean on big pharma. Government has very little leverage. When government told Pfizer to do clinical trials in India, short clinical trials, they said we're not interested and they left. Now they are saying come back and, if it's been approved elsewhere by a stringent regulatory authority, we will let you sell in India. I don't know where we are on that. But as I said, very little leverage. So I think government of India really needs to collaborate and cooperate multilaterally with other key governments, particularly because now it's been invited to the G7 plus meetings which are going on in London with our foreign ministers and next month with heads of state. I think that's a great forum in which India should lead and say, look, if we have to do something, we have to do something together. These are the key governments. We don't wait for the G20 meetings in July, but the G7 meetings itself can be used, I think, to say, not just for India, but for other LMICs also, we need to resolve the issue of vaccine inequity. And I think India should take the lead. India profits in a certain sense by getting most of the manufacture already. There's a lot of manufacture, but again, India's needs are huge also. So we need to have this leaning on, which you said, done multilaterally by the G7 plus countries. That's my view. And I think this is a great opportunity. It's current. The meetings are going on right now in London. The foreign ministers are meeting, and next month heads of state. So I think we shouldn't really waste more time. We should have an international initiative on this. And I have a suggestion, which is in play, hopefully, which is called setting up an international pandemic fund. So something where, when money is given to companies, there are conditions placed on those companies that you have to do certain things. So those conditions were not really, it was just to supply those who gave the money, that is US and EU. So if you have something which is international, those conditions will be going towards fulfilling the objective of vaccine equity.
Yeah, thank you, Jayesh, madam.
Yogesh, just one point. I am saying that internally, Government of India should roll back its new vaccine accelerated policy, because that can, further accelerate the vaccine inequity within India. So that's also important, and they should continue with the old policy which was operational till 30th of April.
Yeah, so we'll just towards the end, we'll take only two questions by our listeners, because they are not on the existential questions on IP, but on the straight questions on how would, and this is by Professor Brian Mercurio, tell us very specifically how can you force trade secret transfers, tech transfers that involve trade secrets which are not part of regulatory test data, because under Article 39.3 you have regulatory test data and 39.2 you have trade secrets. So how do you actually get companies to share trade secrets? Tell us, Gopal.
Trade secret is not a sacrosanct thing. Every year, US FTC looking at the merger and acquisition cases, and most of the time they forces one of the entities to forcefully share the trade secret. So it's not a sacrosanct. So this is happening. Okay, every year US it's happening. Okay, then if you look at the EU trade secret directive, so there is a exception to the trade secret protection, and public interest is part of that. So probably, if there is anything to be done as per the law, and the trade secret is coming on the way, you can force the trade secret. And then there are other like whistleblowers and all, but that's not for commercial use. But if anything to be done, you are having a disaster management act in operation, or you have an essential commodity act in operation, and trade secret come on the way, you can force it. And this is a well-recognized principle in Europe as well as in the US. And US it is happening. The US FTC orders every year 1 or 2 such trade secret disclosure is happening, and therefore even sometimes not even the merging and authorities. Okay, they ask a escrow authority to deposit that trade secret. So this is happening.
So under the Brazilian law, for example, the new law, amended law, they are saying that if you don't transfer your trade secrets, your patents will be revoked. But then that doesn't leave the trade secret question closed, right? I mean, you still have the question of who is going to transfer, even when you revoke their patents and they move out of the country. Prashant, sorry. Go ahead.
Just a second. I'm saying if you have a regulatory reform, then the trade secret becomes redundant in the case of vaccine. Okay. You do not have an accelerated pathway. You have an accelerated pathway which is there in the biosimilar, which is further getting reformed, and will be much more easy to bring the product. So similarly in vaccine also, if you carry out a regulatory reform and you have an accelerated pathway, there are existing some accelerated pathway for some type of vaccine, not as a whole. So then the trade secret become redundant actually.
Okay, Prashant?
See, honestly, this is a technical issue. I don't know. I mean, it depends. If there is a vaccine manufacturer who says that using just the regulatory dossier data, it's enough for me to reverse engineer, reverse engineer and get an approval, and that has all the trade secrets, then I mean, perhaps it can be done. But I'm not a technical expert on this.
And if it can be done, then perhaps it can be done even currently within TRIPS. So that leaves the waiver question still open. But nevertheless, another follow-up question from Rupali Samuel, and this is the last question. She's not too hopeful about Indian courts denying injunctions. So I, for one, I think that no court in India would grant injunctions. But Prashant and Murli, can you throw some light on whether you would advise, because she's asking whether lawyers would advise their clients in India, to risk just launches without even applying for compulsory licenses. Murli first.
in the past, my track record has been at-risk launches, Yogesh.
Yes, I know that. And that's why I asked you the question.
So in those circumstances, we've had kind of mixed results, right? So if you take erlotinib, which is the Roche versus Cipla case, Justice Bhatt didn't grant the injunction and allowed the product to go through. And the distinction that, if you want to be academic about it, you can draw is, that was a life-threatening disease, and this was the magic cure for that, and therefore injunction is not granted there. But if it is not a life-threatening disease, perhaps injunctions will be granted. So you see the gliptin cases, you see the other cases where injunctions were granted. That is the only distinction I can make. But a large number of cases, injunctions are granted. The only one or two that we can find will be cases like erlotinib. So my sense is perhaps they won't grant an injunction during this year if it is for COVID. But, some judge somewhere.
And importantly, Prashant, don't you think that if there are no injunctions granted, those same things can still be exported under TRIPS?
Yeah, no, that I don't know. But
No.
Just to answer your question, if it is on the issue of vaccines, like I said earlier, there are no patents right now covering these vaccines, right? It's going to take 3-4 years, which then means that under Indian law, you can't even sue for an injunction. You can sue for an injunction only after the patent has been granted, although your rights and privileges start running from the time the patent is published, which means you can sue for damages.
Not yet.
So at most, you can file a suit, ask the court to order the defendant to maintain an account of profits, and then use that retrospectively whenever the patent is granted to calculate a royalty rate. It's like a retrospective compulsory license. Now, coming to a factual issue, there was this drug, I think it was written on Spicy IPL. Swaraj or someone had written about it, where the entecavir, somebody was trying to make a generic of entecavir. So this is an anticoagulant drug. It's required for COVID patients because their blood sometimes clots. So the Delhi High Court surprisingly granted an injunction, which was very surprising, although the generic company did make out a case saying that this is required for COVID patients. But I have a feeling today, if somebody were to approach the Delhi High Court, given what these judges have gone through over the last 2 months, nobody is going to grant an injunction for any pharma.
Yeah,
I'm quite sure.
Thanks. Unless anyone has to pitch in, I think we should quickly conclude because we have stepped, I think, 15 minutes over our allotted time. I thank all the listeners, viewers from different parts of the world who have joined us today. And as I mentioned, we are concerned about how to make provide a workable solutions to scale up vaccine production in India and elsewhere. And in this background, we organized this panel discussion today. I thank all the eminent experts who have joined the panel. I thank Professor Rao, who has joined us and delivered the inaugural address. I also thank the DPIIT Ministry of Commerce, who has sponsored this event. And listeners, thank you one and all. I'm sure you have had more questions, but we were not able to answer them all. But definitely, you can still be in touch, and we hope to answer or at least attempt so that we can find some concrete and workable solutions in the near future. Thank you one and all. Thank you and good night. Thank you.
Thank you, Yogesh.
Thank you. Namaste.
Bye.
Thank you.
Namaste.
Bye.